أعوذ بالله أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم إن الذين قالوا ربنا الله ثم استقاموا تتنزل عليهم الملائكة ولا تخافوا ولا تحزنوا وأبشروا بالجنة التي كنتم توعدون نحن أولياؤكم في الحياة الدنيا وفي الآخرة ولكم فيها ما تشتهي أنفسكم ولكم فيها ما تدعون نزلا من غفور رحيم ومن أحسن قولا ممن دعا إلى الله وعمل صالحا وقال إنني من المسلمين ولا تستوي الحسنة ولا السيئة ادفع بالتي هي أحسن فإذا الذي بينك وبينه عداوة كأنه ولي حميم وما يلقاها إلا الذين صبروا وما يلقاها إلا ذو حظ عظيم وإما ينزغنك من الشيطان نزغ فاستعذ بالله إنه هو السميع العليम सदक़ल्लाहुल अज़ीम। जिन लोगों ने कहा कि अल्लाह हमारा रब है और फिर वो इस पर साबित कदम रहे, यकीनन उन पर फरिश्ते नाजिल होते हैं और उनसे कहते हैं कि न डरो, न गम करो और खुश हो जाओ उस जन्नत की बिशारत से जिसका तुमसे वादा किया गया है। हम इस दुनिया की ज़िंदगी में भी तुम्हारे साथी हैं और आखिरत में भी। वहाँ जो कुछ तुम चाहोगे तुम्हें मिलेगा और हर चीज़ जिसकी तुम तमन्ना करोगे वो तुम्हारी होगी। यह है सामान ज़ियाफ़त उस हस्ती की तरफ से जो गफूर और रहीम है। और उस शख्स की बात से अच्छी बात और किसी की क्या होगी कि जिसने अल्लाह की तरफ बुलाया और नेक अमल किया और कहा कि मैं मुसलमान हूँ। और नबी सल्लल्लाहु अलैहि वसल्लम, नेकी और बदी यकसा नहीं है, तुम बदी को उस नेकी से दफा करो जो बेहतरीन हो। तुम देखोगे कि तुम्हारे साथ जिसकी अदावत पड़ी हुई थी वो जिगरी दोस्त बन गया है। ये सिफत नहीं होती नसीब उनको मगर जो लोग सब्र करते हैं, और ये मकाम हासिल नहीं होता मगर उन लोगों को जो बड़े नसीबे वाले हैं। और अगर तुम शैतान की तरफ से कोई उकसाहट महसूस करो तो अल्लाह की पनाह लो, वो सब सुनता और जानता है। सदक़ल्लाहुल अज़ीम। आखिर दावाना अल्हम्दुलिल्लाहि रब्बिल आलमीन।
Jazakallah, Jamal Sahab, thank you very much. Assalamu alaikum, good afternoon. Once again, thank you all joining our session today. Probably some may not know it. I am the senior member of London Victim Family with the incident we had on 6th of June. So I cannot emphasize enough how important this topic is, as after the shock in our family, while we're recovering it, the mental stress, the psychological issues we are going through just because of not having the will is really a tremendous thing. It is incredibly difficult task for us to pierce the family to back together after this incident. So I really see the impact of this issue of not having the will in our case. So I thought although it is, of course, the loss of a family member is tremendous. And you have to go through an emotional journey. But this mental stress, unknown things which has come up now, actually has really given a lot of hope. So, but if we had the will, we could have. I will kindly request all of you to please mute the microphone, but you can have your cameras on. So I think a will would have provided a lot of answer to this uncertainty and tensions. It is simply a legal document, but it's immense importance, especially for the care of the children and the distribution of the assets after the death. So I'm not going to go into detail. That I will leave to Mr. Shahzad Siddiqi. I'm grateful to Mr. Shahzad Siddiqi. In spite, I know he's a very, very busy attorney and also shifting his office. So in spite of his very busy schedule, he's agreed to come and share his expertise. Mr. Siddiqi is a very well-known attorney from our community with almost 2 decades of legal experiences. Probably some of you know that Mr. Shahzad has been involved in several high-profile cases, including the acting for the Canadian Muslim Lawyers Association in 2 religious freedom cases at the Supreme Court of Canada. He did this case in the Supreme Court, and there was one famous case of a taxi driver Mr. Tahir Khan, who was murdered, killed on Mount Pleasant. So he is very well known in that field. Now, he is the founding partner of Broadwater LLP in Ontario. Now, the reason why I selected him, that he is the expert on this topic of will, and he recently published a book titled Islamic Trust and State Drafting in Canada. So I highly recommend referring to his book as a practical guide to Islamic estates and will planning within the context of Canadian law. So today's session is an interactive session. I encourage all of you to ask questions after Mr. Siddiqi's presentations. I understand that creating a will has some difficulty often, but trust me, by providing this document, you can save a lot of problems which one has to face, which creates a lot of mistrust among the families, a lot of misunderstanding, a lot of legal case battle, and loss of thousands of dollars in the lawyer fees. So I think without any further delay, I will turn over and request Mr. Siddiqi to give his presentation. So kindly mute your microphone, and you can have your cameras on. Yes. Mr. Siddiqi.
Thank you very much for inviting me to present to the senior clubs and the not so senior members of your organization. This, in fact, is my first presentation on Zoom. I remember March 2020 and April 2020 when the first lockdown happened. For 2 months, I was essentially sitting at home writing wills and powers of attorney for people because mortality obviously came to the fore. And it's been quite some time in that pandemic situation. Shahzad Rizvi is well known to me, and he reached out to me recently. And you have quite a dynamo in the community with him because he has been after me for a couple of weeks, and I'm glad we managed to get this organized. Obviously, I know the ISNA community well. I've presented a number of times with Sheikh Idris Ali at that organization, and I always enjoy coming there. As is my preference during the presentations of this nature, I like always commencing with the hadith. Many of the Quranic verses are well known, especially Surah Nisa, verses 11 and 12, as they set out a lot of the inheritance distributions within the religion. The hadith are less well known. Perhaps the most important is the hadith that says, learn estate division and teach it to the people, because I'm someone who will be taken from you, and this knowledge shall be taken from you until there comes a day where two men shall dispute about the obligatory share, and there will be no one to judge the dispute between them. So I think it's obviously incumbent to engage with this knowledge. There are many people, imams in the community, who have studied this science. And I don't propose to teach estate division to the people, but what I will address today is the ability to get Islamic distribution and more liberal distribution within the context of a Canadian will, a power of attorney, and an estate plan. So the spectrum in the community tends to be quite wide. Some people obviously apply the strict letter and spirit of the law. Some people are quite liberal, and then there are people in between. So those options are obviously available within the Canadian context. And they're also subject to how people have structured their affairs already, in how they've titled their house and how they've set up their bank account and how they've set up RSPs. And I'll get into those details today with you as well. The second hadith of importance is that no Muslim who has assets to bequeath should go more than 2 days without having a will ready and written with them. And there's some narration that a will should even be under one's pillow. I wouldn't necessarily recommend that. I don't have my will under my pillow, but I do have it in my bedside table, because obviously as someone who engages in this area frequently, I know the importance of having that document, and obviously my wife, who is my executor, knows where that document is. So I do have a presentation that I'd like to share. So I'm just going to share screen that. And then after the presentation, I'll give you ample time for questions that you may have. So this is a little bit more detailed on the flyer that Mr. Rizvi had sent out on our behalf. Thank you very much for doing that. The first thing I'd like to start with is a picture. And this is a picture of Albert Einstein's office on the day that he passed away. And it became an iconic picture, actually, of the day of the death of Albert Einstein. It was done by a life photographer who, instead of going to the hospital or the cemetery, where most of the other people were, he ended up going to Albert Einstein's office at the Institute of Advanced Studies in Princeton and took this photograph. And this photograph made it into Life magazine. And as you could see, Einstein had a very clear mind, but he had quite a messy desk, and he had mathematical calculations on the chalkboard. And I wanted to share this iconic photograph with you because I want you to think about the legacy that you will also leave the world as we go through the presentation and afterwards, not only to your children, but otherwise. So I'm just briefly going to go through the agenda for the day. I'm going to address, obviously, what is a will within the Islamic context. Most people will know, generally speaking, what a will is, but I'd like to get into that a little bit. I'd like to get into kinds of wills that are available in Ontario and what happens if somebody passes away without a will. I'd like to address why one even needs a will in Ontario, given legislation that we have dealing with estates. I'd like to address what's in an estate, because as you'll find out today, if you don't already know, there are a lot of assets that actually don't fall into the estate because of how you structured it. Then I'd like to get into the structure of a conventional will, which obviously the vast majority of Canadians do, but even there are widely different asset distributions that Canadian testators and testatresses do within their wills. And then finally, I'll get into the structure of a Sharia-guided Canadian will for those who are interested in that specifically. So let's begin with the first thing, which is what is a will? Within the Islamic context, historically, a will was allowed to be an oral testification. And for people who've read up on the subject, within the Quran, it obviously talks about the importance of the witnesses speaking the truth about what they've been told about the will. And that's because of the oral testification, people traveling in the desert at certain periods of time, giving that testification to two witnesses. And there's very stern verses in the Quran about not changing what you've been told within the will. An oral testification obviously is not valid in Ontario. It needs to be a written document in this province and across the rest of Canada. It also only becomes active when you become inactive. So this is different from a power of attorney, which is also a written document. And it has various permutations and combinations. So, for example, you could have a limited power of attorney. The classic example of that is somebody who's traveling overseas, let's say to the Middle East or the subcontinent, and they need to get a real estate closing done, or they need authority for someone to deal with the tenants while they're away. abroad on holiday or attending to family matters in another place where they may reside. So it's important at that period of time to put in a limited power of attorney in place so that you can appoint somebody in Ontario, even for example, a real estate agent or a close family member or a friend to do those things for you, to close the real estate transaction and to attend to other legal matters that they might have to attend to while you're away. So a limited power of attorney becomes quite important if you're out of the country and you need to attend to certain things. That's been alleviated a little bit by Zoom, but as we move out of the pandemic, those rules that have allowed Zoom signings and things of that nature will become less and less. And very often people have to check with the vendors and with any financial institutions that those can be properly done through a power of attorney, because not everybody will allow the use of a power of attorney on a real estate transaction, for example. So then another power of attorney is a more general one to deal with all of your properties and other legal matters. And that'd be a very powerful document. So generally speaking, we advise the only person you give that power to is a spouse, and perhaps as a substitute, a child, because essentially if somebody's away abroad and you give that power of attorney to them, they could sell the house while somebody's away. So that's a lot of authority to give someone. They can also bind them under legal matters under that power of attorney. So generally speaking, we'll do that power of attorney only in a situation of incapacity. So if somebody is incapable of acting for themselves, then that power of attorney comes into place because that person isn't able to attend to signing documents and they're mentally incapable of attending to any legal matters. The third power of attorney is a power of attorney for personal care, and that is for medical decisions that may have to be taken into account. So somebody's appointed, generally, again, it's a spouse and a child, to make medical decisions on somebody else's behalf. And that becomes important, generally speaking, in two situations: when there's a situation of dementia and somebody becomes incapable, or even more serious, a situation of coma. The powers of attorney can be very important documents. Without them, you often have to go to court to get somebody appointed as a guardian on behalf of somebody else. If it's not done properly, it can lead to very significant litigation. There's one case I'm involved in right now where the incapable person was a successful real estate businessman, and essentially his family members are fighting over control of the real estate properties because the powers of attorney were never properly done. They were done, but he signed them at home, and there's a question about whether the witnesses had been present at the time he signed them. So that's been under litigation for several years. And between the three main parties who are fighting over that power of attorney and that authority, I would say they've spent in the range of $50,000. So, you know, the estate is worth $20 million, but that's a lot of money for a family to be spending when a power of attorney could be done properly in the first place. And again, this is a person who's still alive, but they're incapable because they're in late stage of dementia from Alzheimer's. So I just want to make sure everybody's clear on the distinction between a will and a power of attorney. The will is a document that takes into effect after somebody's passing into the next life, but a power of attorney goes into effect while somebody's still alive. So the will generally deals with three very important aspects. The first is who's going to be the executor of the estate, otherwise known as the estate trustee, otherwise simply known as the trustee. That person is essentially the banker. They will collect all of the financial assets, make inquiries, pay the taxes, and then distribute once debts, taxes, expenses have been dealt with and they're properly appointed as the executor. Another general thing for, especially for the younger couples, are guardians and custodians of children under the age of 18. You'll need to appoint a guardian and custodian for minor children under your will. And that tends to be the second most important thing. And the third, of course, is directions about asset distribution. That is often surprisingly not a driving force for many people to draft a will, especially, as I mentioned, the younger couples are worried about who will be the guardian for their children after their passing. For the older clientele, asset distribution tends to be the main focus. Sometimes, of course, people use the will to get revenge. I don't know if you could see this cartoon. Probably this is a cartoon from the New Yorker, obviously about a wealthy but disgruntled man speaking to his lawyer. And he's saying, "Now read me the part again where I disinherit everybody." So people would obviously that's not permitted under Islamic law, and generally if you, for example, cannot disinherit a wife on the deathbed, and that goes for a husband as well, because under Islamic law, once somebody is in a situation of the terminal illness, then their estate is already spoken for, so they can't take a drastic step such as that. And so that's something important to take into account. Obviously, under Canadian law, there tends to be more freedom in terms of who you can list as the beneficiaries. But even there, the spouse has certain family law rights that, again, applies to both husband and wife. And so you can't disinherit a spouse under will unless you've already made provision for them elsewhere. And children who are minors especially, or who are disabled, have protections under the Dependents Relief Act. So if they're disinherited under the will, there's a possible challenge there. But generally speaking, once you have those, you have quite a lot of freedom to do in your will what you'd like. This is a picture of a lawyer called Charles Vance Miller, who ended up becoming quite wealthy at the end of his life. He was also a silver mine owner, and he didn't have any heirs. And he ended up doing a will. I've shown you a sample of his will on the screen here. You can't read the provisions, but I'm going to read some of them to you to indicate, again, how much freedom there is under Canadian law, testamentary freedom, they call it. So I've shown you samples of the will. I'm going to read them out to you. So the first section here says, "This will is necessarily uncommon and capricious because I have no dependents or near relations, and no duty rests upon me to leave any property at my death. And what I do leave is proof of my folly in gathering and retaining more than I required in my lifetime." So, as I mentioned, he left a sizable estate. And so in his will, Miller gave $25,000 worth of Ontario Jockey Club stock to 3 staunch enemies of horse racing, and $700,000 worth of brewery stock to 7 Methodist ministers and temperance advocates to see whether their avarice for money was greater than their principles. So I suppose he gave a lot of money to certain people who weren't supposed to be promoting drinking, to see if they would take stock in beer companies. He gave joint tenancy in his Jamaican vacation home to 3 lawyers he knew to be sworn enemies. But Miller saved his most controversial bequest for last. The residue of his estate was to go to the mother of the largest number of children born in the confines of Toronto from the time of his death to the end of the decade thenceforth. The exact wording in the will was as follows: "All the rest and residue of my property, wheresoever situate, I give, devise, and bequeath unto my executors and trustees named below in trust to convert into money as they deem advisable, and invest all the money until the expiration of 9 years from my death, and then call in and convert it all into money, and at the expiration of 10 years from my death to give it and its accumulations to the mother who has since my death given birth in Toronto to the greatest number of children." So that was what's shown in the will here. With a month left in the contest, Time magazine reported that 4 women each had 10 eligible children, with one pregnant woman, Grace Bagnato, a sturdy Toronto-born Italian court interpreter, with 9 children due before the contest ended, hoping for twins. Meanwhile, Ontario government officials cast a gimlet eye on the contest. The government argued that the contest was void as against public policy. The case went up to the Supreme Court of Canada. The issue before the court was articulated by the Chief Justice, who stated, "It is the duty of the courts to give effect to contracts and testamentary dispositions according to the settled rules and principles of law, since we are under a reign of law. But there are cases in which rules of law cannot have their normal operation because the law itself recognizes some paramount consideration of public policy, which overrides the interest and what otherwise would be the rights and the powers of the individual." The Supreme Court justices found that the contest did not contravene any principles found in statute law or judicial decisions, and therefore upheld the validity of the contest. The residue of the estate, amounting to $500,000, was eventually given to 4 winning mothers. Charles Vance Miller's life and last will inspired at least 2 books and a movie, The Great Stork Derby. So that's an example, obviously, of an unusual will. Now, if one doesn't do a will, then that's known as what they call passing away intestate. And there's a common perception that if you don't have a will, the government's going to take it all. And that's promoted especially by my fellow attorneys south of the border. But it's not true. Instead, what the government does is it makes an estate plan for you under a law called the Succession Law Reform Act, SLRA. And the scheme under that act is that the preferential share goes to the wife. So the first $350,000 of the estate goes to the wife. That recently changed. It used to be $200,000. I think given what's happened with the real estate market in the Greater Toronto area and in Ontario in general, I think the government decided that they better raise the preferential share to $350,000. So that first comes out of the estate, goes to the spouse. If there's an estate that's worth $300,000, the whole thing goes to the spouse. Up obviously until $350,000. Thereafter, the rest gets divided between the spouse and the children. So if there's $1 million estate, $650,000 would be shared between spouse and children. If there's only one child, then it goes half and half. So the 650 is divided in 2. If there's more than, if there are 2 children or more, then it becomes 1/3, 1/3, 1/3. So that's something important to bear in mind. Is this will take into effect if you don't have a will in place. Now, if you don't have spouse and you don't have children, then that distribution, all the assets go to your parents, equally divided. If you don't have spouse, issue, or parents, then it goes to brothers and sisters, siblings. Now, the government will look far and wide. This is called the Cox chart. It was developed quite a number of years ago, and you'll see in the middle here, it says a Latin word, propicitus, and that's the testator or the will writer. And generally speaking, they'll look far and wide for relatives to be able to give an estate to. If they don't find relatives, for example, because they're back home, then the assets of the estate escheat to the crown, which are, they go to the government at that point in time if they cannot find any heirs. So it's a good idea in the will, especially if you're from a small family, to put in a charitable institution that would inherit in place of the government, because we all know Her Majesty is wealthy enough. So obviously the natural question becomes, if the government has a scheme in place under the Succession Law Reform Act, why does one need a will at all? Obviously, the first consideration for the Muslim community is the government then chooses the distribution, and that may not be what you want. It would go according to the Succession Law Reform Act, and especially if you've got considerations, including religious considerations, those won't be implemented if you don't have the will. It's longer and costlier to administer an estate. If you have a will, there are essentially 5 documents you have to get registered in the court under quite a simple procedure. The first is an application that contains the will. The second is a notice to the beneficiaries that somebody is applying to be the executor under the will. Then they have to sign what they call an affidavit of service of notice, which is a document that it's a sworn statement that says, yes, we did serve this notice on all the beneficiaries, and we're testifying that we did so under oath. And then the fourth document is a certificate, which is the document that gets issued by the court for somebody to be appointed. And the fifth is the notarized death certificate. If you don't have a will, then there are important documents that come into play. The most important which is what they call an affidavit re debts. And that's a sworn statement that says the deceased did not have debts, or they had minor debts that are going to be paid off by the estate. And therefore, the court should waive what they call a bond. And a bond is financial security you have to put into court in case there are other debts that are outstanding. And that can be quite sizable. It can be a lot of money. You can get insurance for it, but it can be very expensive. And also, if you have a foreign executor, there will be a bond. So again, for people contemplating doing their will, I would recommend you do somebody local in Canada, because if you appoint a foreign executor, they will have to pay a bond or get insurance in lieu of paying the bond. So without the will, it becomes longer and costlier to administer the estate, especially if they're competing claims about who wants to be the estate trustee, because it's not spelled out in a will. And those contests can obviously drag on and cause delay in the administration of the estate and the distribution to the beneficiaries. With children under the age of 18, can get complicated, once again, because of competing claims about who's going to be the guardian and custodian of the minor children. So if you specify that in the will, it becomes clear as to who you wanted to be taking care of the children. And of course, there can be no estate planning, Islamic or otherwise. One example I wanted to give you is what they call a dual will. And this is something that was created by the lawyer of a businessman called Philip Granovsky. He's ran a company that he started from scratch that you may know quite well now, because you see their trucks all over the highways in the Greater Toronto area, and that's the Atlantic Packaging Company. So what Granovsky did is he had a primary will that dealt with most of his assets, including his principal residence, for example, his bank accounts, things of that nature. But he also did a secondary will for his private corporations. So he not only had the Atlantic Packaging Company, he also had some other Atlantic companies. He built this company essentially from zero to a $25 million company, which at that time was a significant amount of money. And by doing a secondary will, he saved his estate $375,000. So I brought my will as well to show people. I can just stop the screen sharing for a moment. So I got a primary will here, primary will and testament, that deals with the majority of my assets. And then I've got a secondary will that deals with the shares of my professional corporation. And although I'm part of a firm, but it's my partner. And so by means of this, I can save my estate some significant probate taxes. And that's why anybody with a private business, regardless of how successful it is, even if it's a startup, will be well advised to consider a dual will. And I can send an article in this regard for people who are more interested in that subject. Just a request, if you could, this microphone. Thank you. All right, so moving along to what's in an estate. I wanted to deal with here the three most important assets that people generally have within their lifetime. The major asset obviously tends to be the principal home. And as you recall earlier, I said not everything falls into an estate. This is a good example. If you are joint tenants with your spouse on your property, so in your title deed, it's going to say the words joint tenants, then the property will fall to the surviving spouse. So whoever's the survivor between the two of you will get the 100% of the property whole and sole. If, however, it says the word tenants in common, very often between spouses, even if it's tenants in common, it won't say a percentage. And if there's no percentage, it's deemed to be 50-50. So if that's the case, then the surviving spouse will obviously get to keep their 50% of the property, but the other 50% will go through the will. So that's an important distinction between joint tenancy and tenants in common, because if it's tenants in common, then whatever the percentage is owned by the other person, most of the time it's 50%, that will be governed according to the will. Sometimes people co-own property with children, so sometimes it's a 25-75% split, with the parent owning 75%, the child owning 25%. So the 75% would go according to the person's will, and if there was no will, according to the law, the Succession Law Reform Act. So real estate is obviously an important one, tends to be the most valuable asset, and so you should look at your title deeds to see how that's been set up between you and your spouse. Then with respect to bank accounts, if you've got a joint bank account with a spouse, then that will go to the survivor. It's called rights of survivorship. Sometimes people have bank accounts with children, and those are set up for convenience purposes so that the children can assist with the financial matters, day-to-day banking and things of that nature. If that's not done carefully, then there might be an argument about whether that account is supposed to go to that child or it's supposed to be given to all the beneficiaries. There's a famous Supreme Court of Canada case called Pecor versus Pecor that says if a parent has an account with a child, for example, then there is what they call a presumption, a rebuttable presumption of resulting trust. And what that means is the child is deemed to actually hold that account in trust for the other beneficiaries. It's not meant to be for that child. But the reason it's a rebuttable presumption is that child can say, no, the money in this account was mainly mine, and I just had my parent on because I was saving the fee, for example, the senior's fee on the account. I didn't have to pay for bank drafts. I didn't have to pay for other banking charges because my parent was on that account with me. That's not my parent's account. That belongs to me. So just to avoid any arguments about this, it should be clearly spelled out in the financial institution why it's being jointly held. And if that's difficult to do at the financial institution because they have very rigid rules, then it's a good idea to put it in the will as to what's to be done with that account and whether it actually belongs to the child or the parent. In between spouses, it doesn't really apply. So if there's a joint bank account between spouses, that presumption of resulting trust doesn't really come into effect. But again, it might be a good idea just to mention so there's no confusion in the will. The third main asset tends to be RRSPs, and life insurance can become quite sizable, especially with $1 million policies that people get through work, for example. With the RRSP, it's going to go directly to a beneficiary. It won't fall into the estate unless there's no beneficiary listed in the RSP. Generally, that doesn't apply because when you sign up for the RSP, they ask you, okay, who's going to be the beneficiary? The second example is if the beneficiary passed away before you, then obviously the RSP and life insurance will go into the estate. Third, sometimes the beneficiary is the estate. So in that situation, the property will go into the estate and then it will be distributed to all of the beneficiaries as opposed to somebody specifically. I also wanted to get into what tends to be some of the other assets. So obviously people have cash. Not many people have cash lying under their mattress anymore. If they do have it, it tends to be in the safety deposit box at the bank account if it's not in the account already. And obviously somebody has, most people in Canada will have a bank account. And those assets, there's a presumption obviously that taxes have been paid on those. So the only taxes that would apply to those at the time of somebody's passing would be what they call probate taxes, which are approximately 2% of the estate. Portfolio investments, those are like stock investments that people have. Those tend to be a general asset as well. Then the house I mentioned tends to be the main one. That, thankfully, in Canada, unlike the United States, benefits from complete freedom from taxes. So your principal residence is not taxed anytime you sell it, for example, within your lifetime. It's not taxed if it goes by way of joint tenancy to a survivor. The only tax that could apply is what they call probate tax, the 2% approximately that I mentioned. And that's if you hold the property in your own name and it's not jointly held with somebody else. It doesn't go by way of rights of survivorship. So let's say it's $1 million house, there'll be $15,000 payable in probate tax on that house if it's in the name of a sole person. Investment properties, however, don't get this benefit from the Canadian government, so they attract what they call capital gains, and there is what they call a deemed disposition under the tax law. So even if the beneficiaries are not selling the property, there are taxes payable immediately, and those taxes are called capital gains, which are half of essentially income taxes that would be payable on those investment properties. RSPs, you've never paid taxes on those. They've been tax free as you draw them out. Obviously, you pay taxes if somebody passes away with RSPs in the account. Then there is a deemed disposition of those RSPs. If there's no beneficiary designated, it will attract probate taxes as well, which makes it important to have beneficiaries designated in your RSPs, even if it's by way of an Islamic distribution. You can put the fractions in the beneficiary designation. RESPs are set up for the children and their education, and even if the subscribers pass away, the children could make use of the RESPs if necessary, and taxes would be payable as they draw them out, so they'll get the RESP net. TFSAs are commonly used. Those are tax-free savings accounts. The amounts in those are obviously tax-free, and you can designate a beneficiary under those accounts. So it's important to do that as well if you have those accounts. Life insurance in Canada benefit from not being taxable, but if they go into the estate, then they will attract that probate tax. So again, if it's $1 million policy, there'll be $15,000 payable unless there's a beneficiary designated, in which case it'll go to the beneficiary directly without any taxes. There are also accident benefits available. God forbid somebody passes away in an accident or even an intentional incident. As mentioned, Mr. Rizvi's family and the recent loss, there will be accident benefits available. But obviously our condolences to him and anybody affected. by that incident and the manner in which it happened. The last one I'll mention in terms of assets are jewelry and stamp collection. Obviously, most South Asian women, for example, will have jewelry. Stamp collection is less frequent, obviously, but I want to give that as an example of tangible assets that may have significant value. Very often, jewelry is spoken for within a lifetime, so there's a common understanding between the family members about how the jewelry is going to be distributed. Some people put bags with names on them in the safety deposit box. To be absolutely safe, you could mention how you want that distributed within the will itself. And I tend to find that people, even in Islamic distribution, like to give the jewelry to the daughters in the family, and especially if they're unmarried daughters. Now, the conventional will, these are the basic things that you need in any general will in Canada. So obviously you need your name, you need to specify an executor who will distribute the assets after gathering them and placing them in a estate account. And if there's real estate, managing that real estate until they decide what to do with them, if they've got discretion under the will. There's a guardian listed for children under the age of 18. There's the asset distribution. We recommend that be by way of percentage. Even on an Islamic distribution, it tends to be by way of a percentage or a fraction. So, for example, a husband will inherit half of the estate of their wife. If they're children, they'll inherit a quarter, and vice versa. The wife will inherit 1/4, 1/8 if they're children. Parents will inherit 1/6 each, because as the Quran stipulates, you don't know if your parents or your children are closer to you. If you have no children, then the asaba will inherit, and that tends to be your father. So then after the spouse, the father tends to get 2/3 and the mother will get 1/3 if there are no children or no siblings. So those fractions are very well set out within the Islamic distribution. But for that reason, we mention that it's better to put a percentage on and not anything else, not a monetary amount. This is an example of a will that I'd like to show you. Similar tragic circumstances. This was a farmer in Saskatchewan who got stuck under his tractor, and he had the presence of mind in that time to take out the knife that he was carrying and to actually handwrite his will onto the tractor tire. The object you can see on the left-hand side is the tractor tire. And it says in it, "In case I die in this mess, I leave everything to the wife." And then he signed it, Cecil Geo Harris. And this tractor tire was actually taken into court and probated as the will of this farmer. But may God save us for an end as tragic as that one. He obviously loved his wife, so made sure she was properly taken care of. Within the Islamic context, as I mentioned, there is fractional distribution. So there is freedom within Islam, but it's in respect to the 1/3 of the estate, not 2/3. People considering an Islamic distribution should keep in mind the Untitled Family Law Act. That's family law legislation that says a spouse gets half of all net family property, and so you got to bear that in mind. If let's say a spouse is getting 1/4 of the estate, then they may have family law rights that they have to exercise within 6 months of somebody's passing. So that's a consideration to keep in mind. When I say you have to set out the strictures, I mean there has to be details in the will, not generalities. So rather than writing, I want my estate to be distributed as per Quran and Sunnah, it's better to put the asset distribution in a schedule at the end of the will. And generally, lawyers who practice in this area, of which there are very few, will have detailed distributions in the will. Now, the Ontario court is wary of getting into religious issues. So I wanted to talk about the meher. The meher was litigated over several years in Ontario. The initial court decision said that we can't enforce the meher. This is a religious obligation, and we're a secular court. We're not going to enforce the meher. So that turned out to get challenged over the years. And eventually the Ontario court started enforcing the meher because they said it's a contract like any other contract. The cases in BC, British Columbia, tend to be very strict on this issue. They have to meet certain requirements in BC for the meher to be enforceable. So there, it's just, there's some reluctance by the court to put these religious obligations into effect. And so that's why I recommend that there be specifics in the will. The other things that can go into an Islamic will are obviously a preamble, directions with respect to a funeral and burial. You can have mention of plots that you purchased. For example, one of my clients is the Toronto Muslim Cemetery Corporation. And so because of the work I've done for them over the years, they've given me 2 plots. And so I can make mention of those plots in my will, so my beneficiaries know that they don't have to purchase those grave sites for me. There are directions you can put for specific bequests, like I mentioned, the jewelry and the stamp collection, a special car, any tangible object like that. Under Islam, obviously, there are certain things that you can give over to. So the 1/3 discretion that you have under an Islamic will, you can give that to a non-Muslim relative, such as a Christian wife. If you're married to a non-Muslim, you can give it to an adopted child who generally will not inherit. The Prophet, peace be upon him, had an adopted child and he did not inherit. Under the will, not that the Prophet left a lot of worldly possessions over to be distributed, but an adopted child is not seen, obviously, as a faraj heir, and therefore provision would need to be made for them under the 1/3 discretionary amount. And the primary use of that tends to be for an endowment, giving to a mosque or establishing an endowment, for example, for water wells overseas. People tend to use those for that purpose, or to give to an Islamic institution, be it a mosque or a charity. There can also be directions regarding debts before distribution, and that tends to be an important one. There is a hadith that the soul is held back by its liabilities, and so this is often an important consideration in the will to make sure all debts are discharged, and that money that you may be holding as an amana that doesn't belong to you needs to be given to the right person. I'm actually going to read some of the things that people have written in their will, to people can have a sense. People here can have a sense of what's been written as a preamble in the will. And these are all from wills that I've drafted over the years. One says, "My family and friends have been a source of strength and happiness throughout my life, and I request them to honor this by keeping close ties with each other and the relatives and friends of their parents, and ensure that their children do so as well. I request all of my immediate relatives and closest friends, for the sake of Allah and out of fear of Him, to settle their disputes and correct their relationships among themselves according to the following orders of Allah in the Holy Quran. So fear Allah and amend that which is between you, and obey Allah and His Messenger if you should be believers." This is from another will. I request all of my immediate relatives and closest friends to what the prophets Ibrahim and Yaqub, peace be upon them, directed their sons. O my sons, indeed Allah has chosen for you this religion, so do not die except while you are Muslims. Here's another one. And let those executors and guardians fear injustice, as if they themselves had left weak offspring behind and feared for them. So let them fear Allah and speak words of appropriate kindness. Indeed, those who devour the property of orphans unjustly are only consuming fire into their bellies. And as the Quran warns, they will be burned in the blaze of hellfire. Another one, my final bequest for my family and children is the same one that the Messenger of Allah enjoined upon his followers, the prayer. I advise and employ my family to have patience and accept Allah's will. This concludes my last will and testament. I am now free in front of Allah from any words or deeds that distort and contradict this document according to the guidance of Allah's Messenger, as forewarned by the Quranic verse. Then whoever alters it, that is the bequest, after he has heard it, the sin is only upon those who have altered it. So you could keep that in mind. And lastly, there was an inquiry about the book I had published recently in March. So because there's very few lawyers in Ontario who do this type of will, I've hopefully made it easy for the people and for lawyers who are otherwise not adept in the Islamic distribution. And so this will book is only 60 pages of actual content, and the rest of the 150 pages are will precedents and trust documents and gift agreements and things of that nature. So for anybody interested in delving into this subject in a deeper manner, I would recommend you to that. And finally, for anybody who'd like my contact information, which I will circulate through the very capable Mr. Rizvi, you can get that information from him. Jazakallah khair. And note the time is now 6 o'clock, and I didn't really want to go beyond the hour, so this time I'll take questions. I think we can start with.
Yeah, just Shahzad, thank you very much. First, I'll stop the recording.